This is Indian country in the Arctic. A few general housekeeping things. One, I think as we go, just like if you have questions, just feel free to like raise your hand. I'll call on you. I try to keep things pretty like open-ended. That way we can kind of answer things as we go rather than having you guys have to wait and answer them all or have all your questions answered at the end. Also, I may at some point ask like open-ended / Socratic type questions. Hopefully / ideally we have a lot of engagement for that. The more we kind of get that going, the more we get a pretty good discussion and learn. So for background, there's a couple goals with this lecture. First is to provide you a general background on Indigenous governance in the United States in general, and then in the Arctic more specifically. Second is to describe a number of relevant considerations for how you might debate about both indigeneity and Indigenous governance in the Arctic in the upcoming season, and then to describe some of the common criticisms related to Indigenous governance and the particular form that it takes in the Arctic. So for some terminology, first is generally how do we refer to or think about Indigenous people who live in the United States and also in the Arctic. It's important to recognize that Indigenous people are a diverse group of multiple nations, multiple heritages, multiple peoples and lineages. A couple of terms that may come up across both the lecture and literature, whether that's more like arguments related directly to the effects of a plan or to like critical theory in Indigenous governance. First is the word indigenous. Indigenous just refers to anyone who's descended from a population who occupied an area prior to colonization or significant migration. So there are Indigenous people all over the world. Anywhere where there has been colonization or great migration, there is Indigenous people. So Indigenous does not necessarily refer to the North American context. Next is a term that you might see in some contexts is First Nations. First Nations is a term for Indigenous people which is typically only used in the context of Canada or by the Canadian government. This is relevant for the next year's topic, but in general, because there are a number of Indigenous groups, especially in the Arctic, who share ancestry and also ancestral homeland, which spans across the border between the US and Canada. Still, though, this is generally only used in the context of Canada, so is not as applicable for some of the discussions we have. Next, Native American, or more plainly Native, is generally considered acceptable and proper terminology for the Indigenous people of North America. It properly conveys that they're individuals who are native to the area which is now the United States and generally occupied the North American continent before colonization by Europe. And finally is the word Indian, which is a misnomer in the context of any American Indigenous people, but particularly Indigenous North Americans, which finds its origin in European colonizers' mistaken belief that they had discovered trade routes to India. So the original goal was setting sail from Europe was to like sail across the ocean, and they thought they would wrap around the whole world, and then they would like land in India and spice trade, etc. So the question becomes, Judah, why is the elective called Indian country in the Arctic? So the word Indian, while not preferable language for describing Indigenous people, has precise meaning in the context of both legal studies and settler colonial studies. It is the word used by the United States legal system, which dates back to early colonialism and the establishment of the legal relationship between the US and Indigenous people. So Indian country then refers to any land which falls within a native reservation in North America, or more expansively, any land to which an Indigenous group recognized by the United States has a similarly recognized claim to a specific area of land by the US government. So anywhere you see the word Indian as in Indian country, federal Indian law, Indian treaty law, anything like that, while that is not like the preferred language, it is relevant insofar as that is a language that has to be used for something to be like considered legally precise in the context of US law. So going forward, the importance of that is that at any point in the lecture, if the word Indian is used, it refers to a very specific and precise like legal sort of context. Otherwise, we'll use the word Native and Indigenous. Okay, so timeline. We're gonna start with the general timeline / overview of sovereignty rights and Indigenous sort of governance in the US, and then we're gonna compare that to the Arctic context. So settler colonialism in the US has a long, complex, nuanced history. It can't be given an exact timeline. It's not always super precise. It's not exactly linear. but we're going to focus particularly on governance structures, law, and the relationship between the United States and sovereign indigenous nations. So sort of the major starting point, or at least a major starting point for analyzing the development of indigenous governance and sovereignty, is the Supreme Court case of Johnson versus McIntosh in 1823. So in a unanimous opinion in Johnson versus McIntosh, the Supreme Court found that only the government, rather than Native American tribes, held title to the land that they lived on. The opinion argued that the patterns of discovery during European colonization of the New World meant that each European nation gained sovereignty over the land that it discovered, and that this trumped the right of occupancy of the Native American tribes, at least with regard to specific colonizing powers. In the situation of the US, this right had previously belonged to the British when they first acquired the colonies, and then the War for Independence meant that the United States had then inherited that right to property. The sort of background for this case was an individual had bought a piece of land from a native group who had historically lived on the land. He then passed it down to his family. There was basically a dispute over who actually had the land. And the sort of underlying basis for this was that the Supreme Court found that Native communities basically didn't have the properly civil forms of society in order to be property holders, or that they did not have the capacity to be proper owners of property and land. And so therefore they could not sell their own land because they essentially held their land in trust. So later, when we get into the reservation system, the importance of this is that while indigenous people in the United States have reservation which is designated and recognized as their own, and they are recognized as stewards of that land, they do not actually own that land. So Johnson versus McIntosh establishes that indigenous people do not actually have the right to sell their own land, nor do they have ownership over their land. Rather, they have right of occupancy and stewardship. So the Indian Appropriations Act in 1851 establishes the reservation system. This system created a system of reservations on which Native people lived but did not own. For most of you who maybe live near indigenous communities in like the lower 48 or in the contiguous United States, the continental United States, this is probably the form that you recognize the most or like are familiar with. There's like a set aside area of land or community in which indigenous people might live, and they kind of have independent communities. There's a complex system of governance and sort of like legal pluralism in which certain jurisdiction is given to indigenous people, certain jurisdiction is maintained by the federal government. But generally, this kickstarted the violent dispossession and relocation of indigenous peoples. Many of these reservations, or even most, were not on the land where indigenous peoples historically actually lived, and even the ones that were not obviously the fullness of that land. But this also laid the groundwork not only for violent dispossession and relocation, but a number of problems related to sovereignty, land claims, and recognition. So the question of indigenous people living on reservations, the question became, one, are they independently and recognized sovereign nations that are separate and distinct political entities from the US? Do they have claims to their land? And what do those claims look like? So Johnson versus McIntosh established that they do not have ownership, and so thus they can't sell the land. But beyond that, left the door pretty wide open in terms of understanding what types of rights indigenous people did and did not have to their land. And then also, to what extent does the United States recognize different indigenous groups? So moving to the Arctic context, in 1867, the United States acquires Alaska. You probably learned about this in some of your history class, like your 19th century history. Then gold is discovered in Alaska in 1896. This becomes particularly problematic for Alaska natives who are living in the area because as gold prospectors come up and industry booms in Alaska and people come up looking for riches, they ultimately end up dispossessing, moving, exploiting Alaska Native communities who are living in the area. So much of the economic growth that comes from Alaska, much of the resource extraction comes at the expense of a lot of traditional practices which exist. Certain trades become disrupted. The patterns of migration for particular species, which are important to basically tribal practices, are disrupted. And then in addition, the gold prospectors are the sort of American settlers who are going up into Alaska undertake a significant amount of violence. So when there's Alaska Native communities who pose an obstacle to, or pose a perceived obstacle to what these gold prospectors or people looking for resources, when Alaska Native communities were basically had land or had claims to land where there was gold, there was a significant amount of violence that was sort of taken against Alaska Native communities, which obviously disrupted their way of life, their communities, their livelihoods, their safety, a significant amount. So this goes on for a while, but Alaska remains a territory. Alaska received statehood in 1959. There involves a complex process of basically land selection where the federal government looks at the territory, they determine a certain amount of these areas are eligible for the state of Alaska to claim as their territory within the state, and then there are some protected areas which the state cannot claim. That becomes a little bit important later for how we think about some of the indigenous land claims, but the major part for how we should think about indigeneity and indigenous governance in the Arctic is the Alaska Native Claims and Settlement Act in 1971. This is often abbreviated to ANCSA. This conceived of a different model of sovereignty, primarily because it established what are called Alaska Native corporations. So distinct from the reservation system, which happened in the rest of the continental United States, where there is a set-aside piece of land that is considered trust land, and indigenous communities are considered the trustees of that land but cannot sell that land. Alaska Natives were worried about their relative ability to maintain sovereignty, claims to the land, and claims to resources which is on that land, and their ability to reap the benefits of economic development that was occurring in Alaska as they discovered gold and then later also oil. So the sort of compromise or mode of sovereignty that is conceived of is a corporate model in which the state is divided into 12 regional corporations and 200 village corporations, and tribes receive recognition not as sovereign and independent nations that are trustees of land, but as non-profit or for-profit corporations which own land and provide dividends to their members. So this was intended to produce greater sovereignty over resources, strengthen claims to land, and provide an alternative mode of recognition that would depart from historically exploitative models, but there were disputes over whether or not this would actually do that. So we'll deal with the corporate model later, but moving forward, in 1978, Congress establishes the Federal Acknowledgement Program. Basically that there are a number of indigenous tribes who will be recognized or acknowledged as being sovereign, or at least just recognized indigenous groups. And then there are many indigenous groups who live in communities today in the United States but are not federally recognized as sovereign nations. So the federal government establishes this Federal Acknowledgement Program, and then in 1994 they revise it and they place Alaska Native tribes on the group of recognized tribes, or recognized groups. This sets the groundwork for a number of legal disputes about the extent to which Alaska Native tribes can be considered basically Indian tribes. So again, going back to our discussion earlier, the phrase Indian refers to a very precise legal definition, but basically the significance of ANCSA is that federal Indian law, or the United States law governing indigenous people, drew a distinction between the lower 48 or the continental United States, all of which contains Indian tribes, and Alaska Natives, who by and large have a different historical relationship to both colonization and just in general a significantly different heritage, a significantly different set of relationships to a number of systems. So in 1994, Alaska Native tribes being placed on the federally recognized list of nations becomes problematic because it lays the groundwork for questions of, do Alaska Native corporations and or Alaska Native tribes count as federal Indian tribes as designated by the list, and also as similar to the rest of the tribes in the lower 48. So then the case of Alaska versus Native Village of Wenatchee Tribal Government in 1998 held that Alaska Native corporations were not sovereign nations in the same way that, quote, Indian nations were. This case drew a distinction between Indians as covered by federal Indian law and Alaska Natives. The justification for this was primarily that the legal regime governing treaty law, negotiation, recognition, and more were all different for Alaska Natives given their historical relationship to colonization and more. A strong basis for this is primarily like the treaty law that was established first when the United States was established between indigenous nations and the United States. Some of the factors regarding like the incorporation of the federal reservation system, the lack of a reservation system in Alaska, etc. That all of these are fundamentally distinct factors that separate Alaska Natives from the rest of indigenous nations in the United States. And so thus the Supreme Court held that Alaska Native corporations, for the purposes of classification under being an Indian nation, were distinct. This generally was considered the fact until 2021 in the case of Yellen versus Confederated Tribes of the Chehalis Reservation. This case concerned the Indian Self-Determination and Education Assistance Act, which is also known as Public Law 638. Public Law 638 is basically a law which establishes a system of grants intended or aimed at sovereignty for indigenous nations. So the way that it works is basically it establishes specific programs regarding primarily or significantly education, but also a number of other factors, and allows indigenous nations to apply for grants, receive money, and then contract their own programs locally as opposed to relying on the federal government for assistance. This is intended to improve self-determination and sovereignty. This law basically was the means by which the CARES Act, which you might have heard of, which was a COVID relief act, determined a certain amount of money would go to tribal government. So within the CARES Act, it's like a giant bill giving a bunch of money to different places. Part of that is we're setting some money specifically aside for tribal communities. And then it says tribal communities as determined by the Indian Self-Determination Education Assistance Act. So the problem with the ISDEAA, as it's sometimes known, or Public Law 638, is that its language says, basically, it specifies the status of Indian tribes, including Alaska Native corporations and Alaskan village corporations. The problem with this is that tribes or indigenous communities in the continental United States sued the Department of the Treasury, basically arguing that the comma or the need to specify including Alaska Native corporations indicates that there is something distinct about Indian nations as recognized in the continental United States versus Alaska Native corporations as exist in Alaska, and that this was consistent with the court's previous holding about the status of Alaska Native corporations. The court ended up deciding that Alaska Native corporations do in fact qualify and must qualify as Indian tribes in order to give effect to their express inclusion in the ISDA. So even though no Alaska Native corporation had been previously recognized as an Indian tribe, that because they are indicated alongside the existence of, quote, Indian tribes in the Indian Self-Determination Education Assistance Act, then Alaska Native corporations can in fact be considered tribes, or at least are considered tribes for particular purposes. So for the purposes of, for example, assistance, grants, etc., Alaska Native corporations can qualify as independent nations or as sovereign nations and should be considered as tribes, but the door is still pretty open as far as the official status of whether or not corporations function as nations. So that's a little bit of background that kind of lays the groundwork for some of the other considerations, or for thinking about how you might want to think about or debate about indigeneity and governance in the Arctic. So this is all important primarily because as far as U.S. land is in the Arctic, there are no reservations of indigenous people in the Arctic. There are sovereign nations or questionably sovereign nations based on the interpretation of the status of Alaska Native corporations. There are most certainly people who have legitimate claims to political sovereignty, but in general, there is only one reservation in Alaska. It falls outside what most people would consider the Arctic. It is in the way southeast. So for the most part, the way in which indigenous governance is handled in the Alaskan context is through the Alaska Native corporate model. So the corporate model, as mentioned earlier, there are 12 regional corporations. So the state is basically broken up into territories, and then those territories are contain the legitimate land claims of corporations. and then there are about 200 village corporations, which are smaller. So village corporations work alongside or in conjunction with regional corporations, but represent the specific sort of interest or identity of more local villages. So there being only 12 regions means that it's entirely possible that multiple villages of a singular sort of heritage or villages of different indigenous heritages live in the same regional corporation. And so the importance of the village corporations is that they're intended to represent the specific interests of local communities. Some corporations are for-profit, some are non-profit, but they operate as corporations, and then registered members entails being essentially a shareholder. So whereas being a registered member of a tribe in a different context in the continental United States might entail the ability to live on a reservation or to participate in particular municipal functions or things like that. Being a tribal member indicates that you own some degree of share in your representative Alaska Native Corporation, and then you receive dividends pretty regularly from the sort of operations of the corporation. That was a lot. Does anyone have questions about any of the processes and or things sort of governing that structure? Yeah.
Yeah, for the distinction between like for-profit corporations and non-profit corporations, does that have like any effect in how they actually operate in terms of like?
Not in a way that I think is super meaningful for the debate context. Like internally, yes, that has some implications for how they operate. That also has to do with some of what we'll talk about later, which is basically there is often tension between what a community wants and the operations of a corporation. So there are some people who would criticize the Alaska Native Corporation model as incentivizing for-profit in some instances in ways that violate some people's like actual desires or their like sovereign rights, but not anyway in terms of like how they're incorporated or how they relate to legal structures now. Were there any other questions related to any of that? Okay, perfect. So now we're going to talk a little bit about some of the common criticisms and or ways that you could incorporate some of your knowledge about Alaska Native corporations into sort of debating about indigeneity or indigenous governance in the Arctic. So I want to open this up a little bit. What do you all think are some common criticisms of this model and or ways in which this could relate to other criticisms of settler colonialism in general in the Arctic?
I guess like they're forced to make their governance structure into a Western form of like a Western form of like governance, for example, cooperation, as they are forced. They're forced into a cooperation, which is not something originally like they structured their government as.
Yeah, 100%. So this is one of the most common forms of sort of criticism of this model is that, like you said, it forces into cooperation. It also forces into assimilation with a number of sort of things that some people would consider Western constructs or Western contexts. So one is like there are generally critiques of any model. Like this is a critique that could be leveraged at both the reservation model and the corporate model is like you force a sort of like mutual but still dependent relationship between indigenous people and the United States government. And that is one that there are a lot of people writing about. But also the form in which the corporate model does that specifically lends itself to, for example, capitalism, right? So saying that the only form of recognition that indigenous people can receive is through being properly capitalistic actors is problematic for a number of reasons, but particularly entails one, that the United States government does not have interest or the ability to actually recognize indigenous people as sovereign nations, and two, that the only reason the indigenous that the U.S. government would recognize indigenous governance is to receive benefit, right? So in order to get recognition, you must labor, you must produce, you must extract from your ecosystem, you must function as a corporation in a way that produces wealth for the United States, and that is the only way in which you will receive governance, or you will receive recognition from the United States, would be a criticism of the corporate model. So that's really good. That's a very common one. Does anyone else, either bouncing off that or similarly, have thoughts? Yeah.
I think you can take a lot of problem with like the fact that these corporations are all divided, so it's like the partitioning of land, whereas traditionally a lot of these tribes would migrate around the land where they wouldn't like stay in one position. So like this like bordering, this creation of borders causes like internal like divides and like this recreation of like the government is always in control of where these indigenous people stay and reside in.
Yeah, 100%. So the sort of creation of these territories or these boundaries, or even the notion that like you as a corporation should own this land, when historically Alaska Native people in particular, like you mentioned, tend to have more like migratory patterns, tend to not consider land something that is owned but rather something that is maintained or something that is lived on, that is an imposition of a certain logic about owning property, about relating to ecosystems. It's entirely possible / is true that a lot of these sort of barriers or like the borders between territories which are owned by Alaska Native corporations oftentimes break up into historically like continuous or like indigenous groups which have similar heritage. You can also imagine that it's problematic. Like we mentioned earlier, there are indigenous communities who exist in what is today like both Alaska and Canada. So if you have a corporation which is claiming to represent the interests of an entire indigenous group, but a significant amount of those people who share that sort of ancestry and share that heritage are not represented by that corporation because they live in Canada or what is now Canada, you can imagine that gets pretty problematic in terms of, one, how we conceive of representing Native people, two, how we think about like their sort of relationships to land or ecosystem, or our lack of consideration for how Alaska Native communities historically think of their own relationship to ecosystems. Yeah, real good. Mm-hmm.
I think you briefly mentioned this just now, but I know that a lot of Alaska Native communities were migratory before colonization, but then were forced to stay in one place by the Western model or the Americans, like forced model. Yeah,
100%. So like historically, just based on a number of factors. One is just based on like the way in which communities just like had lived for a long time and did live, and then also based on like weather patterns, climate, etc., the relative ability to like survive, moving with certain practices of like hunting and fishing, especially that a lot of Alaska Native populations were historically pretty migratory. The corporate model suggests that you have to stay in one place. This is tied to the idea that property and land are always static, that they stay in the same place, and that because they stay in the same place, that you are able to own it, you are able to extract from it, you are able to take things out of it, and then that you can imagine that in a process of production, this goes back to the process that we talked about earlier, in which the only form of sort of recognition that indigenous people can receive from the United States government is a relationship in which they produce for capital and produce for sort of the Western world. Then ignoring historical cultural practices, you have to stay on this land, you have to extract from this land, and from a productive perspective, it is much more consistent and productive in terms of output to be staying in the same place and continually extracting from the land, regardless of whether or not that's sustainable, to stay in the same place, continue to extract, and then to be able to establish relationships of capital and its movement, which benefits larger corporations, benefits Western governance structures, benefits, oil. You can connect oil to like energy dominance, Western hegemony. Like the sort of connections that you can make to a lot of these things are pretty expansive and can have a lot of arguments related to them. But yeah, very good. Anyone else? Thoughts? Yeah.
I think you were touching on this like earlier about like this like kind of like the dependency of like indigenous people on the state, and like they're forced into this system again and again, like especially when you're talking about like the economic aid that was given, I think the CARES Act, right?
Mm-hmm.
And like I think that really highlights the fact that the state has placed indigenous people into this like way of like being, but then like they're reinforcing that by like making sure they kind of stay independent.
Yeah, 100%. So the critiques of dependency are very good, especially because you can imagine how like a corporate model or the suggestion that Alaska Native people should function as corporations in relation to the way that they are still dependent on the state means that they are also dependent on the market in a lot of ways, right? So the suggestion that the way out of your dependency or the way to assert your sovereignty is through remaining dependent to the market or remaining reliant on the logics of sort of a market system and participating in a market system suggests that then when they are dependent, that it's almost like, oh, it's Alaska Native or it's Indigenous people's fault because they weren't able to play the game right? Like, we gave you all this land to go set up your corporation. Why have you not succeeded within the market system? And the real answer is like, because there's this maintenance of a dependent relationship with the United States, but a market logic suggests that they have not like properly played the game of the market basically and have not properly, taken advantage of their resources. And that also goes back to like what we talked about earlier with Johnson versus McIntosh, right? So who remembers what the reasoning in Johnson versus McIntosh was? Or who remembers what that case established? Yeah.
Wait, was that the one where they said that Indigenous people weren't like capable of owning land?
Yeah, exactly. So like that was the one that held that basically Indigenous land was trust land, but it was actually owned by the federal government because Indigenous people did not have the proper civility or the proper like social and legal structures to actually like properly govern owning property, right? Or like owning legal systems of property. And so you can connect that then to now the corporate model says, well, okay, we will give you legal claims to your land. You actually do own your land now, but then maintaining a dependent relationship to the government and then seeing the sort of like economic deprivation that comes from that dependent relationship suggests that, oh, we were right all along. Indigenous people don't have the sort of proper logic or proper ability to participate within a market system, and that is related to, or that suggests something from the perspective of a colonial U.S. government about the way in which Indigenous society is capable of acting, or capable of being or developing. Yeah, anyone else? I thought I saw more hands. I don't want to skip over anyone. Okay, cool. So the last couple notes in terms of like existing criticisms or like critical theory based stuff, this was touched on a little bit, but critiques of extraction or extractive relationships. So basically the notion that the corporate model is an excuse to feel better about and or normalize extractive relationships to the Arctic via colonialism and capitalism. So for the United States to go in basically and like establish, one place that this comes up a lot is man camps. Has anyone heard that phrase before about man camps? Or like fossil fuel drilling leases on native lands? So this goes back to, again, another reason why like the federal government is capable of leasing drilling projects on native lands, or like the Dakota Access Pipeline, for example, going through native lands, goes back to the fact that Indigenous reservations or Indigenous land holdings are actually trust land and not land owned by Indigenous people. And so it's technically federal lands, which means the government can like, in specific purposes or for whatever reason, go through and do stuff. So one place that this is common is the United States on or near Indigenous reservations, more so in the continental United States, because that's where all the reservations are, will establish what are called man camps, which are basically fossil fuel drilling projects, which send workers for extended periods of time to just like work on these temporary projects to like extract a bunch of oil out of the ground. This is problematic because a lot of times these man camps, as they're called, tend to feature a lot of like male workers who oftentimes are near Indigenous reservations, and there's a correlation between the existence of these and a lot of violence against Indigenous communities, but particularly like missing and murdered Indigenous women, if you've heard that phrase before. So many Indigenous women will be subjected to multiple forms of violence, gendered and ungendered. If you can consider any violence against Indigenous women ungendered, that's sort of like a separate debate that can be had. But this happens a lot of times, and there's a lot of pushback against this because people are like, well, the US government shouldn't be the ones who are able to like just like assume responsibility for this and go like establish these man camps and then like wipe their hands and not do anything about these missing and murdered Indigenous women. So while the aspect of like man camps, for example, is one aspect of violence, there's also another aspect of violence that's like the sort of colonial climate devastation that happens and the way in which a lot of these extraction projects which happen in ecosystems where Indigenous people live then affects their way of life. Some would consider the corporate model a way of the United States trying to make itself innocent and or feel better about or justify or normalize any of these extractive relationships which suggest extraction on Indigenous and or native land that happens, disrupts ways of life, disrupts ecosystems, etc., that it is somehow okay just because the like people in charge of an Alaska Native Corporation said so, right? Or the justification that Native people are then receiving the benefits of this economic development or whatever. In the grand scheme of things, the forms of like energy security or the forms of like energy profits that happen massively outweigh the economic benefits received by Alaska Native corporations. But it provides, at least on face and at least through a logic of the market, a justification for normalizing these sorts of extractive relationships. This is also related to one historical debate. Well, it's related to disputes between basically corporation leaders and tribal members, or disputes between village corporations, which represent particular villages, and larger regional corporations. So this happens often, one, in the context of these extractive projects, so oil drilling or like energy projects and that kind of stuff, or any sort of extractive project which happens, because that's a lot of the economic development that goes on in Alaska. There are oftentimes tribal members who will dispute these types of things and suggest like this violates a historically important and sacred practice. You should not do this. And the Alaska Native Corporation, because whoever its sort of like leaders are, like whoever the like executives are of that corporation, will go ahead and do it anyway. So some have suggested that a profit motive or profit incentive incentivizes a mode of governance in which leaders are more concerned with profit than they are with representing their constituents. And that goes back to like what you mentioned earlier about like, is there ever like, do for the for-profit corporations in particular have like unique problems, or are they like different in the way that they're governed? Not necessarily, but many would argue that the for-profit corporations are often incentivized to break with the wishes of a lot of their constituent tribal members who they're responsible for representing. Another place that this comes up is oftentimes like even outside of the Alaskan context. So these corporations are basically, they're corporations, they're free to take on whatever sort of economic projects they want. So one place that this came up recently is like, if you go way back to like late January, early February, with the Trump administration. So this comes up in certain contexts with like Trump executive orders expanding energy dominance via like Alaska. He signs like an executive order specifically about Alaska, and like is trying to court a lot of like Alaskan Native populations to be able to like get them to sign on with his energy projects, basically, which are like massively extractive. So Alaska Native corporations were insulated from having to revoke their DEI bans. There's a number of other things that like Trump has done to try to sort of navigate a good political relationship. But this became a big deal before like Alligator Alcatraz, before CCOT, when they were housing detained migrants at Guantanamo Bay. It was discovered that the new like migrant detention centers that they were building on Guantanamo Bay were being contracted by a subsidiary of an Alaska Native corporation, right? So there were a lot of debates about like within, especially like people debating this context, were like, what are the ethics of like a corporate model which either for profit motive or just for sort of other reasons, like why should, like there are very few people who would be like, Trump is our decolonial hero, you know what I mean? Like Trump is probably not good for decolonization. And that's not to suggest that all Indigenous or Alaska Native people want like a radical project for decolonization. It is obviously a very politically diverse group, but there were a lot of people who were suggesting that our aim is decolonization, or if our aim at least is to not have dependence on the US government, to not have the economic exploitation of our communities, to not have the exploitation, like, what is our relationship to other indigenous people? So, for example, Dene people who are being detained by the Trump administration, or like by ICE, right? Like, indigenous Americans who like live in, like, they were here before the existence of a US colonial government, and ICE is like, no, you're being deported. And it's like, what is our relationship to other indigenous, or what is the relationship of Alaska Native people to other indigenous people? What are the ethics of sort of Alaska Native corporations' participation in this type of thing? So the other critique that is related to extractive processes is related to the critique of sovereignty, or the critique of sovereign recognition, is that many times the sort of governing structures, or the means by which governance is established, puts people in power who are more favorable to the colonial power, and that, one, does not properly represent the population at large, which means that it is not a true form of recognition, but two, that it is generally bad for decolonization, or can have effects on other people who are sort of subjugated or exposed to violence by colonization. Yeah, the final critique related to sovereignty and sovereignty's questions is that a corporation model is basically a failure to recognize an alternative to a corporation. So we've talked about the sort of like Cap K style link angle that's like, you only want recognition as a mode of production, right? And so you only recognize indigenous people as being capable of producing. But the flip side of this is that, in addition, the US government is incapable of recognizing a truly distinct political entity for indigenous people. So this would draw a connection between the corporate model and the reservation model, insofar as it recognizes the reservation model as being, well, you can hold land in trust, but you're not a sovereign nation. You're not an independent political nation of people with its own political interests and political governing structures, right? Similarly, the corporate model suggests a progression that even moving away from the existence to hold, or the ability to hold land in trust, that Alaska Natives are refused recognition as a political entity, and that they will not be recognized as a political entity. Thus, like, there is a critique of whether or not we should be, or not necessarily we, but should decolonial projects be searching for political recognition as sort of the root or as the basis of decolonization, or should instead decolonial movements and people's interested in decolonization, should they be pursuing alternative means of decolonization, of recognition, of resisting colonialism and economic exploitation? Yeah, are there any questions and or other thoughts related to that?
When the government goes to build something on these like corporations' lands, do they only discuss with the these corporations, or is it like more broadly?
Well, so that's kind of like the key difference with the corporations, right? Is where, for example, man camps, the federal government would say, well, this is our land. We have the right to lease this to like an energy company, right? With the corporate model, its intent was that, well, this corporation owns this land as a private entity. It is not entrusted, so the federal government has no land claim to this, whatever, so they can't do it. Where the projects on those lands and the like extractive relationship to ecosystems and communities comes is that then the corporate model is like the corporations are the ones contracting with the federal government. So if like there is a particular regional corporation that has like a particular area that's really good, like has a bunch of oil, for example, it is likely that like that corporation is structured in a way that like that corporation functions largely or has a division that is an oil company or an energy company, because the corporations are also divided according to like what resources and opportunities for economic development are in that area. So like if the government wanted to contract with that company, or like anyone who wanted to like purchase a particular amount of energy or whatever, they would go contract with the company that owned the corporation that owns that particular area of land, and then that corporation would be carrying out the project, which is why like a lot of people are like, no, it's justified, like they're receiving profit and they have choice over whether they do it. But that goes back to the question of like, does this represent the interest of who they're supposed to be representing?
So then like in terms of like a more debate context,
Mhm.
when all these affirmatives are like saying we like consult, we discuss with indigenous people,
Mhm.
is it mainly through these corporations?
Right. So like that's a question that you could ask them, and like that, in my opinion, you should ask them is like when they say you like, oh well, we consult the indigenous communities. It's like, how do you consult them? Who do you consult? Do you consult regional corporations? Do you consult village corporations? Like, what is the deal here? How do you know which ones to talk, like which indigenous people to talk to? Like, this also poses problems for like not so much given the like CARES Act tribes can be considered sovereign nations for particular purposes. Like some of that puts a little bit of a wrench in this, but like the apps that are like give $1 billion to indigenous peoples to do whatever they want in the Arctic. It's like that there are implications for how that would actually play out in terms of the primary means by which they do that are these corporations, and there are significant areas where like indigenous populations are not represented by their like Alaska Native Corporation who is supposed to represent them always. This also like the other place that this becomes relevant is with a lot of the Trump stuff right now. So like from a it's like if you are saying we're going to give money to indigenous nations, right? Even if the AF isn't prepared to debate this, there's a way of probably setting something up where it's like the CARES Act, for example, if Alaska Native corporations are capable of being considered nations, it is likely that they are the regional corporations are likely to be the ones who are receiving a significant amount of this money. And like, if Trump has a favorable relationship with even some of those corporations, then it is entirely possible that the projects they get are not going to be building climate adaptation infrastructure. It's going to be extractive projects. It's going to be energy dominance. It's going to be like, asserting U.S. hedge via Alaska, right? Like, you are correct to identify that like a lot of the implication for AFs that are, or any position that's like, we're going to consult or we're going to give money to indigenous people, that the corporate model is a significant factor in how that plays out. Was there any other questions and/or thoughts before we depart? Awesome. Cool. We'll stop that.